Daniel Konikoff, the floor is yours.
Good morning. I'm Daniel Konikoff, the interim director of the Privacy, Technology, and Surveillance program at the Canadian Civil Liberties Association, and I'm also a member of the steering committee of the Right2YourFace Coalition. The Right2YourFace Coalition is a collection of experts from across civil society and academia calling for legislation to regulate the use of facial recognition technology in Canada. Facial recognition technology is a powerful and invasive tool that is being used by actors across the public and private sectors, from law enforcement to shopping malls. It's a technology that matches photos to perhaps the most sensitive and vulnerable data we have, the biometric data of our faces, the visual information that makes up who we are. As we've seen countless times in Canada over the past few years, facial recognition can threaten our right to privacy and our right to equality, as our biometric data can be taken without our consent and fed into notoriously spotty algorithms that often misidentify members of equity-deserving communities. This past June, the Right2YourFace Coalition released a joint letter expressing our concern about the government's response to a parliamentary study into facial recognition and artificial intelligence. In that letter, we reinforced the parliamentary committee's recommendations, including, among others, the recommendation to impose a federal moratorium on the use of facial recognition technology until Canada can implement a more robust regulatory framework for it. We also reinforced their recommendation that Canada develop a regulatory framework that better protects biometric information and that increases transparency around the uses of facial recognition technology and that protects individuals from mass surveillance. There's been little movement here on this front since we sent that letter back in June. However, a new opportunity to redouble our calls for stronger regulation of facial recognition has presented itself in Parliament's current study of Bill C-27. Bill C-27 features Canada's updated private sector privacy legislation, as well as new and woefully underdeveloped legislation around artificial intelligence. We are concerned that there has been no commentary or discussion on this bill's troubling implications for facial recognition. Our joint letter, which we have sent out this morning, highlights the need for more robust protections here and points to vulnerabilities in Bill C-27 that, if left unaddressed, will only make facial recognition flourish, threatening rights everywhere. So over the next few minutes, you're going to hear from a number of Right2YourFace Coalition's experts. And first, I'm going to throw it to Sharon Polsky.
Thank you so much. And I agree, members of the coalition and their members, our members, understand the potential for positive outcomes when companies and governments use biometrics, like pharmaceutical giant GSK, that's mining the 23andMe genetic data as it researches new medications, and when it's used to catch people committing crimes. We also understand the broad psychological and social implications of being subjected to facial recognition, biometric categorization, and so-called emotion recognition as we go about our lawful activities, living in a panopticon that we didn't ask for, weren't consulted about, and have no wish for. Yet AI and biometrics have already transformed the way we live, work, and interact. Canadian grocers already use live facial recognition, so someone banned from one store is automatically banned from every single other grocery store owned by that company. The faces of everybody who walks into an airport or retailer, approaches a border, or returns from abroad are already instantly cataloged, analyzed, identified, and shared internationally with airlines, law enforcement, and we don't know who until we are denied entry. Or the single American company that used AI to analyze over 6.6 billion messages from Slack and other collaboration tools that employers require we use that we've been assured are confidential. AI is neither artificial nor is it intelligent, and its use is largely unregulated. So while it has provided some benefits, those are matched and often outweighed by the harms to society and individuals who lost their homes, their jobs, their children, and their very lives because the AI didn't get it right or the facial recognition misidentified them. These are just a few examples of the hidden cost of AI and biometrics that are glossed over in favor of commercial and economic benefits that the innovations promise to offer. We're told that AI and biometrics are important to protect us or to protect organizations from us committing fraud and other crimes. But research has repeatedly confirmed that facial recognition results are unreliable. Yet hundreds of millions of dollars are spent every year by Canadian municipalities, airports, retailers, schools, and of course, law enforcement that embed more and more AI and facial recognition systems for safer communities. We've all been put under a microscope operated by public bodies and companies because they can. And Bill C-27 won't change any of that. Facial recognition and biometric collection will still be fair game if companies or public bodies justify its use according to any of the many self-serving exemptions that will allow companies and governments to use the technologies. If the past is a predictor of the future, Bill C-27 and the use of facial recognition and other biometrics will continue to threaten lives, and it will jeopardize Canada's adequacy status granted by the EU, which itself called for a ban on the use of private facial recognition databases, and has acknowledged, the EU acknowledged, that the impact that lobbying has had on by big tech has had on regulations has been massive. So our members and other people across Canada cannot afford bad law, and Bill C-27, make no mistake, is bad law because it undermines privacy and it freely trades away Canadians' privacy rights for the sake of commercial gain as it further erodes trust in government and industry. Now I'll hand it off to my colleague Fenwick McKelvey at Concordia University. Fenwick?
Thank you so much, Sharon, for those fantastic comments. So I'm here today to really emphasize that we're at a critical juncture for the development of artificial intelligence policy in Canada. Presently, we've been focused on artificial intelligence as an economic opportunity, and we've lagged behind around dealing adequately with its social impacts, and particularly the committee meetings around C-27 are an opportunity to get that right. This, however, is brought with considerable concern about the process and the nature of the development of the ADA amendments to C-27 and the undermining of the committee process presently with untabled reforms and amendments. So right now, not only is our concerns about, or my concerns about ADA, about the content of the bill, but also the process of Canada's artificial intelligence governance strategy and are lagging behind our peers internationally. I'd like to point out two critical concerns that is shared by the coalition members. One is a concern over high impact systems, and second is a concern about certain carve-outs, particularly national security carve-outs in the bill presently. As Sharon mentioned, the C-27 and ADA only provide a category for high impact systems and do not necessarily call for a moratorium or bans, as we've seen in other counterparts, particularly in the EU, but also more recently in the United States with the executive order on AI, both which call for guidance and specific reforms to specific sectors, including housing, labor technology, and as well in the EU with specific bans on biometric technologies. So in one sense, what we see is an inadequacy in ADA about being able to draw distinct red lines and no-go zones, and as well as ensuring that the capacities of assessing high-risk applications or no-go zones are built into the law. The present use of a data commissioner without a broad mandate, with unclear coordination with the Office of the Privacy Commissioner, raised significant issues about how we will be able to enforce and actually action the EDI committee's recommendations on facial recognition technologies. This inadequacy is something that we can see in other jurisdictions has been met, and there's been more clear guidance on where the bans and where the red lines are going to be. The second issue directly is that there is broad exemptions in the bill presently for certain applications of artificial intelligence. This includes national security issues and the ways that artificial intelligence might be used in problematic context, but more broadly, it misses the government's own coordination around automated directive on automated decision making and work on implementing AI in the government presently. So not only do we have this bill not giving enforcement powers to the work the government has already done, it leaves broad categories of high-risk applications untreated and leaves Canada unprepared for the potential consequences of these technologies being deployed more widely. So with that, I'm proud to be part of this coalition calling for reforms and for a better, stronger approach to AI governance in Canada. And with that, I'll pass it to my colleague, Christelle.
Thank you, Fenwick and Sharon, for those great remarks. Facial recognition technology and other biometric surveillance technologies, when left unregulated, open the door to a variety of collective harms. Collective harms look like human rights violations and the reinforcement of systemic forms of discrimination such as racism, sexism, and homophobia. At a technical level, research has shown that these systems perform very poorly on Black, Indigenous, other racialized communities, LGBTQ folks, elders, children, and disabled people. And even when these systems properly identify people, they subject marginalized communities to even more surveillance. This looks like racial profiling in Black communities in the country, Indigenous communities as well as Muslim populations across the country. These are not speculative harms. To date, there have been 6 reported cases from the federal court of individuals challenging the use of facial recognition technology to revoke their refugee status in Canada, all of which involve Black people, most significantly 5 Black women. These are the documented cases that we are aware of, but there may be a greater number of incidents in the country in a variety of sectors. Je vais aussi parler en français. Je veux aussi vous rappeler en fait de l'enquête conjointe du commissariat à la protection de la vie privée et des homologues provinciaux qui avait révélé que Clearview AI avait enfreint les lois sur la protection de la vie privée du pays et aussi des provinces. Bien qu'il avait été ordonné à Clearview AI de supprimer les images et les données biométriques faciales recueillies des Canadiens, il n'y a pas de garantie à cet égard. C'est pour ça que avoir des lois concernant nos données biométriques nous permettrait de prévenir des cas intrusifs comme Clearview AI. Lorsque nous parlons des torts collectifs ou de groupes, nous parlons des violations de la charte, notamment du droit à la sécurité contre les fouilles, les perquisitions ou les saisies abusives, le droit à la protection contre la détention ou l'emprisonnement arbitraire, la liberté de réunion, la liberté d'association, etc. Si j'avais le temps, je ferais une présentation énumérant les différents scénarios pour chaque section de la charte. With Bill C-27 currently being debated in the House, the time to act on facial recognition technology and biometric surveillance is now.
Thank you. Merci, Christelle. That concludes the remarks portion of this press conference. We're now going to open up the floor to media for a Q&A. If you could please, if you have a question, raise your hand, provide the name of your outlet and who you would like to address your question to. Nous allons maintenant passer à la portion de questions-réponses avec les médias. Si vous avez une question, s'il vous plaît, levez la main et une fois la parole donnée, indiquez l'agence avec laquelle vous travaillez ainsi que la personne à qui vous voulez diriger votre question. I'm just going to note that Sharon Polsky as well as Fenwick McKelvey are joining from Montreal, and Christelle and Daniel are joining us from Toronto today. So I will now open up the floor to questions.
Hi, good morning.
Yep, go ahead, Natasha.
Natasha O'Neill, ctvnews.ca. I'd like just some clarification, I guess, on where these technologies are currently being used. Like, if we could just have some like non-jargony kind of answers in terms of like, are they being used in airports? Are we seeing them like the cameras in grocery stores? Just so that I can understand, I guess, like where in the public and how they are interacting with the public, if you will.
Daniel or Sharon,
believe Sharon tried to speak, but she was muted.
Yeah.
Sharon, yeah.
Yep.
I'll be happy to help you out, Natasha, on this. Certainly the cameras with live facial recognition are being used in airports across the country and other countries, not only when you check in at the gate for your flight, but as you enter the airport. They're used in grocery stores. I had some very interesting discussions with people in some of the major grocers who say, yes, as somebody walks in, if they have been banned for having been suspected of shoplifting, they are immediately apprehended and escorted out. But that also means that they are not allowed into any one of our grocers' chains stores. And there's a handful of grocers in this country. So if you're banned from one store, where do you get your groceries other than a dépanneur, a corner store? It has massive implications. More hidden is the artificial intelligence that is being used to things like identify whether you might be a good tenant. More and more landlords are using artificial intelligence-based apps where if somebody wants to rent an apartment or a house, they have to fill out the application online, where the system, the artificial intelligence, grades them and gives a score. And it pulls information from things like your social media accounts, from anything you've posted elsewhere, from your bank. It draws from a lot of sources that you don't know, and you have no option but to consent, which of course doesn't make it real consent. And it'll say whether the artificial intelligence determines that you might be a flight risk, that you might move out without paying your rent. Decisions about this sort of thing are being made without people's awareness. In fact, the Privacy and Access Council of Canada did a quick survey of the landlord and tenant authorities across the country. One of them had heard that there is something like this. And this is a year and a half ago. Commissioners and the regulators aren't aware of these tools being used, so how can they protect us? For jobs, for parking, the artificial intelligence that assesses the information in the GPS location generated by your phone and your vehicle, not only for the insurer to personalize your rates, but also to identify your comings and goings. Whether your vehicle went from this particular address every morning, so presumably your home, to a church, a school, a mosque, a synagogue. All of these bits of information are being assessed and analyzed and communicated to others without our knowledge, without our consent. We have no direct relationship with these organizations that are using these tools for safety and safer communities.
I'd also like to hop in and add that there are documented examples of facial recognition being used in shopping malls. As I mentioned in my opening remarks, for example, a few years ago, Fairview Mall was investigated by the privacy commissioners for putting facial recognition in information kiosks to analyze shoppers and their shopping habits and track them throughout Fairview property. Concretely, there is also police use of facial recognition, which is being used to compare suspect images, which occasionally are being gathered without proper consent or oversight and compared against mugshot databases. And there is also recent reports that Christelle had mentioned on top of Clearview AI, which had featured so prominently in policing, but with the Immigration, Refugee, and Citizenship Canada instance where Ministry of Transportation photos were taken and photos taken from the Ministry of Transportation's databases of driver's license photos were used and ultimately revoking refugee statuses of people. So those are a few other examples. I also saw that Fenwick had raised his hand and Christelle has her hand up now. Oh, Fenwick is deferred. All right, Christelle.
Yeah, and another additional example is in schools. Over the course of the pandemic, we've seen proctoring systems being used in elementary, secondary, and post-secondary institutions. So even minors have had their data included in databases, and that is very concerning.
Thank you. We're now going to go to Jim Bronskill, the Canadian Press. Jim.
Hi. The Minister of Industry recently presented some amendments to the bill to the committee studying it. And there was a section on some of the things to do with AI and specifically biometrics and facial recognition to do with high impact systems, as you mentioned. And one category would set out regulation concerning the identification of an individual other than if the biometric information is processed with the individual's consent to authenticate their identity or state of mind, that sort of thing. There is some mention of some of the things we're talking about today, and it might cover this. So I'm just wondering if these amendments in any way, if you're familiar with them and if they in any way ease your concerns.
Fenwick, go ahead.
I just want to say at a high level, the introduction of the amendments speaks to a point that is that the process of ADA being introduced, drafted, responded to, and developed is quite problematic. And the fact that the amendments were introduced at the start of committee and had to be subsequently requested, and I'm still unclear of their status about whether they're going to actually become part of the bill or it's just speculative, but it really shows a kind of undermining of the legislative process and the opportunity of committee members to actually make tangible, meaningful feedback. And the fact that it only was at the launch of the committee that we actually see these amendments, even though ADA has been around for a year, I think really speaks to a deep concern about just the actual good governance of this entire process.
Yeah, and yes, we are familiar with the proposed amendments, but compared to some of the already floated amendments that cover the Consumer Privacy Protection Act, there are no tangible proposed amendments, even regardless of this pretty egregious question of process. We still haven't seen what those actual tangible amendments look like. So, you know, what they like to say about legislation is, you know, the devil's in the details, but we don't have any details here, right? And I'd also say that even with that proposed idea around protecting biometric information, there are still holes between both parts of the bill, right? If we're going to look at the CPPA and ADA and see how maybe the CPPA talks about how data is collected and disclosed, but follow that data flow down to how that data is ultimately used in artificial intelligence systems, we still don't see that biometric information has any meaningful protection in the CPPA at all, which is quite confusing, especially considering if you look to the European Union, you have the General Data Protection Regulation, which very clearly lays out a crystal clear definition of biometric information with crystal clear examples. We don't have that here. So even with those proposed amendments, which again, I would love to see them actually written out. I also would love that we're not in this position with this pretty silly process, but we can't really do anything about that now, can we? I'd still love to see more biometric protections baked into the CPPA.
Any follow-up on that, Jim?
Only I know you have your letter today, and the committee is continuing its work. Will you have an opportunity to say the things you're saying today to the MPs? I know that you know it's kind of a moving target, but will you have a chance to do that?
Yeah, actually, Sharon and I will be appearing before the Indu committee tomorrow afternoon. So I think we're going to direct these comments at them specifically.
Okay, thanks.
Thanks, Jim. And sorry, Natasha, I realized I didn't give you the opportunity for a follow-up, but if you had one.
Yeah, I actually did want clarification on those examples that you guys had given. Are those because people like quote unquote did not consent? Because I'm thinking in the terms of like when we talk about privacy in particular. Almost all Canadians, I suppose, are on social media. There's videos and pictures of them everywhere. And so when you go on said social media app, you obviously consent in a way. So when we're talking about like grocery store cameras and things like that, just as an example, that those are instances where Canadians are not committing to having their photo video taken. Is that where is that correct?
That's part of it. I agree. Canadians, if you're not aware that there's a camera watching you and analyzing and identifying you, you have no opportunity to consent. But to say that anybody who goes on a website consents, that's a fallacy, because even Mark Zuckerberg, when he presented to the American Congress and said he himself doesn't read these privacy policies, he acknowledges that most people don't. They consent. They click consent and click through without understanding what it is that they are agreeing to. And even if they do read the privacy policy, so-called, the language in it is allowed to be so vague as to be meaningless. And that's what fuels a data brokerage industry that's already in excess of $300 billion US and predicted to be over $545 billion US by the 2028. So people don't know what it is they're agreeing to when they say, I consent. I consent to the organization using my personal information for legitimate business purposes. Anything that is not illegal, that improves the company's bottom line, can be construed as a legitimate business purpose. When people call up a website and they aren't aware that the website is secretly already transmitted their presence to Facebook and others in the surveillance economy, the surveillance data chain, how can you consent? Yet that's exactly what happens when there's hidden metapixels embedded in a website. People don't have an opportunity to consent. And even if they do consent, there's no relationship between them and the ultimate user. If they don't consent, what real option do you have? If all banks have essentially the same terms, if all car companies have essentially the same terms, if all pick an industry have essentially the same terms, and there is a very clear power imbalance, you have no real option but to throw up your hands, give up and say, yes, I need the service. And although every piece of privacy legislation in Canada has wording to the effect that an organization is not allowed to refuse to provide a good or service just because somebody refused to consent to the collection and use of their information, that's exactly what has happened all the time under PIPEDA and other privacy laws. So consent right now is meaningless. And Bill C-27 doesn't improve it.
Thank you, Sharon. Are there any further questions from members of the media? Y aurait-il autre question des membres des médias présents? No further questions? Okay. This is going to conclude our press conference. Thank you all for joining us today. Merci à toutes et à tous d'être parmi nous aujourd'hui. Ceci conclut notre conférence de presse. Bonne journée.